Hi everyone, this is week 14, lecture 1, and there's going to be 2 videos. In this first video, we're going to talk about a strategic interaction. So in Easton's black box, going back to that black box, so we have the law school model, particularly looking at precedent and also the text that influences judges or justices. Then we have role perception, how judges ought to behave. Some argue that judges should abide by judicial self-restraint. Others argue judges should engage in judicial activism. Those individuals do pay attention to precedent and do pay attention to the legal writing, but they also are influenced by different approaches to the Constitution. Then you have under that attitudes and values. Siegel and Spaeth that you read argue the modes of constitutional interpretation are garbage, that in fact judges are principally influenced by their attitudes and values, and we know that because we look at the voting behavior of justices, and conservative justices vote conservatively, liberal justices vote liberally. So if I had to identify how any justice is going to act on the Supreme Court, especially in this day and age where we're picking polarized justices, I just need to know their party identification. And I can tell you how they're going to vote across all types of issues, whether it's civil rights and liberties, whether it's criminal, or whether it's economic issues. Now we're looking at strategic behavior, which is in the black box, the last influencer of judicial decision making that political scientists that study judicial decision making have looked at. So if you think about appellate courts, whether you're talking lower appellate courts where you have 3-member judges, or Supreme Courts where you have multi-member, U.S. Supreme Court, 9 members, California State Supreme Court, 7 members, they are members of groups. And as you know, when you're ever a member of a group and engaging in decision-making process, you're influenced by other members of the group. You have a group product, a decision, and so you're talking amongst yourself about making that decision, and that can influence different members of that group. Why we have multi-member courts is simply because several heads are better than one. But advocates of strategic interaction argue, and this approach argue, that one cannot understand how justices engage in decision making without looking at how they interact in small groups. So the choices justices make are impacted by other members of the decision-making process. So in the notes, the hypothesis is that since justices want to be on winning sides of coalitions, okay, so at the Supreme Court level, we're talking a winning side of a coalition of 9 members, 9 members is 5 justices. They develop strategies to try to build winning coalitions when they're in that decision-making process. This approach does not deny, number one, that there are some loners out there. Like anybody else in a group, there are those loners. And an example on the Supreme Court was Justice Black. He could care less what others thought. He was going to go by his approach. He was an absolutist, and Scalia is very much like that, not really caring what other people think. Nor does it deny that other factors influence judicial decision making, such as the legal model looking at precedents, looking at the text, or the framers' intent that wrote that particular provision in the Constitution, or in an amendment, but or attitudes and values. So they don't deny framers' intent, precedent plays a role. And they also don't deny that attitudes and values play a role. But they argue a third element is important as well, namely attitudes and values. Given group dynamic in appellate courts, the fact that justices change votes between conference and final decision, the final voting stage, small group interaction necessarily takes place and plays a role in the decision-making process. Obviously, it's important to note that small group interactions play a much greater role at second level appellate courts. I'm talking Supreme Court level, whether you're talking state or federal. Than in first level. And part of the reason is the workload. The workload, as Baum mentions, the workload in intermediate appellate courts is heavier. They have far larger workload than the U.S. Supreme Court. As you know, the U.S. Supreme Court only grants cert to around 70 cases a year. So because they have a larger workload at the intermediate appellate level, whether you're talking state or federal, there is an assumption that the judge that writes the opinion, assigned to write the majority opinion, is representing the entire court, and others tend to support it more readily than on Supreme Courts. Second, at the intermediate first level appellate courts, those are judges sit in rotating panels of 3, as you well know, whether you're talking state or federal level. So there's less interaction among the judges at that level than at the Supreme Court level, especially in the Ninth Circuit, where you have 27 judges at that level. Third, the other reason why there's less strategic at the first level appellate courts is intermediate appellate courts tend to uphold trial court rulings. So agreement between the judges are far more likely. The question is, how do you study this? How do you study strategic interaction, whether you're talking about intermediate appellate level or Supreme Court? And I really want to focus on the Supreme Court level and looking at the U.S. Supreme Court. And in looking at that, to assess that, you need to look at, as I told you, the conference stage. Initially, what they were looking at, scholars, political scientists, were looking at the initial conference stage versus the final vote. But as you know, conferences are secret, and there's no secretary in there. So how do they determine this? Well, what they've done is they've looked at the writings of the justices themselves. Like Justice Brennan wrote extensive notes of what took place in the conference process. And so they'll look at memos, they'll look at diaries, but basically notes taken by the justices themselves that are later released. Unfortunately, in Canada, they're not released until after the justices are dead, which might be years and years and years. So once they're released, then you can look at the differences between what happens at conference and the initial vote that's taken, and then the final vote. So the question is, there's a great deal of switching that does take place between conference and final vote. So it raises a number of questions. Number one, does that change the outcome of the case? These changes rarely reverse the initial decision. So rarely do you go from a 5-4 majority to minority, and then the minority becomes the majority. That only happens in 14% of the cases. So when is vote switching most likely? There's not much evidence that vote switching takes place more readily in landmark cases than trivial cases. So the question is, if that's true, then why bother? Why bother if the switching isn't changing the vote to even bother? Well, as you know, what you as an opinion writer, you know that a 5-4 ruling is a weak ruling. So as the opinion writer, you want to draw as many people in the minority to your majority vote. And to do that, you're trying to create a more unified decision, an 8-1 decision rather than 5-4. So switching occurs to, you're trying to create a stronger majority opinion. So as an opinion writer, you're trying to write the opinion in a way that draws more people to that opinion. Switching also occurs to produce a more comfortable working environment. You are with these people on the Supreme Court for 30 years in the United States, sometimes. And so you want to create harmony. And so you will agree to join the majority opinion because you're trying to increase harmony and get along with others on the bench. Better relations. Third, an individual justice is acting very strategically, might hold out and say, I am only going to, basically the initial might be a 6-3, and the 3 holdouts might be trying to get the majority to change sections of the decision. So they hold out and say, we will join, but you need to scratch out X and add Y. And so they hold out to get a more, a menial, better decision that reflects their views. So that's acting strategically. You initially dissent because you don't like where the majority is going, because you want them to add X, Y, and Z, which changes the opinion, but it meets closer to your goals than what was originally stated in conference. And this is very important because it can influence, obviously, the direction that law takes in the future. This is written down, and it's the law of the land, so lower courts and lawyers have to follow it. And so if you're able to expand the decision to include more of what you want, you might hold out to do that. So initial studies were looking at the relationship in terms of strategic action of what happened in between the conference and the final vote, and looking at changes and where those changes occurred, not as much more prevalent in landmark cases than non-landmark cases, which may be surprising, but also that it's used strategically by both the majority opinion writer to try to get more people on board, as well as the dissenters to try to change the opinion so it mirrors more of what they want in the opinion. This ends the first video of strategic interaction.